Hi everybody, welcome to my channel, Life, Law, Bin.
Hi everybody, welcome back to the channel. It's good to see you again. I hope that you're doing well. Today I want to speak about life as an advocate. As many of you may know, if you follow me on social media or are on my LinkedIn, you would know that I am an advocate, or also known as a county court advocate. So I wanted to invite you into my life today. So I do have some clips that I will attach to this video with me commuting to court across the Northern Circuit. Also some videos with me just briefly speaking to you on my journeys to court to represent clients as well. So what is this episode about? I'm going to attempt to convince you to become an advocate if that's something you are interested in doing. So I will speak to you about why you should be an advocate. Well, actually, I'll talk to you about what an advocate does first and foremost, and then I'll tell you why you should become an advocate, the nature or role of being an advocate. I'll talk to you also about preparation before hearing, and I'll also talk to you about advocacy and what you should be doing post hearing. Now, what exactly are advocates? So, advocates like myself exercise a right of audience in accordance with Schedule 3, Paragraph 1, Subsection 7 of the Legal Services Act 2007 as an exempt person. So, advocates assist in the conduct of litigation by being under the instructions and supervision of a solicitor. Now, our assistance is mostly found by appearing on behalf of clients in hearings which were historically heard in chambers. Now, if you want to find out a little more about the types of the hearings, I will tell you some of the hearings that I do. But if you'd like to consult some legislation on that, you can refer to the County Court Rules 1981 for the types of hearings that were considered in chambers, and those are the hearings that we attend. Now, why should you become an advocate? It definitely enhances your analytical skills. It improves your advocacy skills as well. So many of you would be exposed to the cross examination technique, the examination in chief technique as well, and stuff, things like closing arguments, making submissions. So on the bar course. And some of you that would have done the solicitor's course may have been involved in some activities where you have to use your oral advocacy. So it does improve these advocacy skills because you need to be persuasive in your delivery. It also helps you to improve your client management skills because you have to liaise with your professional client, which is your solicitor who's instructing you as well, or who's provided you with your instructions. And you also have to liaise in some hearings with your lay client. You also have to develop your client conference skills because often you may have to conference with your lay client, and very often your opponent. So whoever is opposing you in the case, whether it may be a litigant in person or a representative. It allows you to also become very comfortable making submissions in front of different judges with different styles, who like different styles. Now, many of us who were recently in school became accustomed to presenting in front of teachers and your tutors or your lecturers. And this is a very different experience. And if you're thinking about becoming a barrister or using the gift of the gab, you definitely need to start to become comfortable making persuasive submissions in front of judges. And I know when it first starts, it can be a bit intimidating. It also permits for flexible working. You control your own hours and your caseload as you are self-employed. So the way it works, you can determine your own hours. You let the companies that you work with, company or companies that you work with, know when you're available. That's also very helpful. It allows you to work in other roles because it's so flexible. So, for example, I work for two different companies. That means I take instructions through two different companies. But some advocates are paralegals as well, or they're working in other roles. So that means that you can easily accumulate income from different sources. You also work on a particular circuit, so you get to move around a lot to different courts. I'm based in the north, so I work on the northern and the northeast circuit. So I'm around courts like York, Wakefield, Hull, Doncaster, Huddersfield, Leeds, Manchester, Harrogate, Skipton, quite a few places. I like it because I'm not chained to a desk all day. So if you like to move around like myself, this is definitely the job for you. You also get sometimes to network with advocates and solicitors. Now, I know it was a bit of a weird period when we were under lockdown, um, or when the restrictions were now lifting. We were doing a lot more remote hearings, so it was a bit of an isolated job. But now that things are opening up, you definitely do run into your fellow advocates when you move around or when you go to court. So it's always fun and it's always lovely to have a chat. So do get involved if you like networking as well, and socializing with your peers. It's also a unique experience to discuss on pupillage or even training contract applications. So I hope I've convinced you about the positives of becoming an advocate. Now let's talk a bit about the nature of the role involved. So I want you to keep in mind that you need to do thorough preparation and case analysis. So many of you would have been exposed to case analysis either on your bar course or your LPC, which is the solicitor's course. But you do need to do thorough case analysis because these are people's lives in your hands. I'm not saying that you weren't doing thorough case analysis while you were undertaking your studies because it was fictitious papers, but no, you really, really need to be doing thorough case analysis. So you want to be doing things like your chronology to make sure that you understand all the events and the sequencing of the events. You need to identify the strengths and weaknesses of your case so that you can make the most persuasive submissions while mitigating any weaknesses, because sometimes you are against litigants in person, um, and sometimes you are against other advocates or solicitors or even counsel. So you always want to be making sure that you're doing the best possible job that you possibly can deliver. It's also about managing client expectations. If you have lay clients that you're dealing with, you want to be simplifying that legal jargon. You want to be explaining their role in the hearing in certain circumstances. For example, I do small claims. So with the small claims hearings, these involve road traffic accidents road traffic accidents or road traffic collisions. Um, we usually refer to it as collisions in the court and not an accident. Um, and you want to obtain their perspective. Lay clients like when you obtain their perspective on the evidence. And it would obviously be up to you if you think it's a strong point, you want to highlight it in your closing arguments, obviously having put that to the witness in while they were taking the stand. But it's important to talk to your lay client, especially in those kind of situations, because they're the ones that experienced it. They may also have a point that you probably didn't know, like a very minor point about the road, drive, how often they drive on the road, etc. So do obtain their perspective. Um, Aside from that, in terms of the professional client, you also would be discussing instructions with your professional client, which is your solicitor, highlighting any discrepancies in the papers, requesting more information as well, because most of the time you may be reading something and you recognize, okay, hang on, something is missing. For example, I'm seeing reference of a counterclaim. However, I'm not seeing any further information on that. Or for this particular case, some particular notice is missing, which can be detrimental to my case. Let me just clarify or double check with the solicitors that they do have this document. And if they do, that they can send this over. to me so that if the judge asks for it, I have it to hand. Now, do remember with the lay clients, as I mentioned earlier about managing expectations, you don't ever want to be telling someone, yes, it's 100% certain that we will win today. Because one thing I've learned, court is highly unpredictable. You don't know. Deliver the best service you can, be as persuasive as you can, but remember to manage those expectations. Okay. In terms of the types of hearings that I do mortgage possessions, mortgage applications, landlord and tenant matters, return of goods hearings, small claims hearings, particularly road traffic collisions, infant approval settlements, summary judgments, application to set aside judgment, order for sale, dispute resolution hearings, directions hearings, charging orders, and other civil applications. So you can see that I am gaining a wealth of experience in different areas of laws and getting to grips with different areas of law and making the necessary submissions. Now let's talk about conferencing. So I conference with my client in certain situations, and I also conference with the opposing party. Now, why do we conference with the opposing party? I'm sure that most of you, all of you, are clever enough to know this, but definitely it's in an aim to ascertain their position and relay their position to my client. In some cases, based on the client's instructions, we can narrow the issues and reach some agreement. But remember, you can't reach an agreement on your own. You must always phone your solicitors, ask them, relay that information to them, tell them, look, they have suggested X and Y, and I know that we are seeking this. This is our main objective. Could you instruct me further? And they may very well tell you, we are happy to accept that position. We are happy to reach some kind of agreement. Or, on the other hand, no agreement is reached at all in conference, but at least we know each other's position clearly on the claim, and there's no real surprises when we step into the court. Remember, just a point that you should note, remember that if you are preparing on the train, because you would notice that I move from city to city, if you are preparing on the train, be mindful of people around you. You should not be exposing people's information. This is sensitive stuff, people. You don't want to be breaching person's personal data. That is a serious issue because sometimes the way you're situated or you're seated on a train. I know sometimes the train journeys can be a bit long and you want to do the work, but you have to be mindful of peering eyes and you have to be careful with people's information. So be careful with physical papers and leaving your laptop unlocked and available for persons just looking over your shoulders. Remember, breaching of data protection is a serious offense, and it's something that you will have to report and discuss with the company that you're working with, and they will have to take further action. People entrust us with their personal and sensitive data, so we must act accordingly. And we must act in their best interest. I know that you want to maximize efficiency and your time management by working on the train, but you have to use your discretion and use it well. So for example, I don't work on busy trains. I just don't. Um, you may be tempted to, but I just don't. That's a no-no for me. The train is packed, it's cramped. There's nothing I think that I can do to stop someone from easily just glancing over my shoulder. I do work on empty trains. When there's no one around me, um, the next person might be in the next carriage. Then you can use that. But it's you have to use a discretion here, people, and just remember that you need to be protecting person's personal information. Now let's talk a bit about the advocacy. This is the exciting bit, isn't it? It's not rehearsed. I think that's the first thing we should get to grips with. So it's best not to have a script, but key points. Thorough preparation will be your friend. Now, When I say have key points, you just jot those down on a piece of paper or you jot them down on your laptop, but it's really best not to have a script. I know that when we were on our bar courses, most of the time our tutors or markers would be very polite to listen to you go from point 1 to 10 eloquently, but you have to be flexible, you have to be adaptable to suit your judge. And sometimes the judge may ask you to deal with issues in a different order. So you need to be flexible. Now, I usually begin all the time with what I'm seeking on behalf of my client. This can save you a lot of time because sometimes the judge already agrees with the order you are seeking. Now, imagine if you don't tell the judge at the beginning of your advocacy what you are seeking or what your position is, and you just start making submissions. You could have saved your time a lot. You could have saved yourself a lot of time, and you could have saved yourself also frustrating the judge, because the judge may just have to interrupt and say, "Look, I'm with you. What exactly do you want? Okay, well I'm with you," and you could have saved yourself some time. So always remember to start with what you are seeking or what you've been instructed to obtain. As I said before, judges don't want to hear your well rehearsed submissions, so know those key points well because the judge can ask you suddenly about a point you may address. So be flexible, as I said. Try to be structured, try to be as structured as you possibly can. So you let them know, flag your points. You all know this. So start, right? My main submission is this. So you let the judge know, I will be addressing you on the following points, the following 3 points. You let them know, flag it all the time so that they're following you. Look up, engage with your judge, make sure that your judge has the relevant paperwork that you will be referring to, because you'd be surprised to know that even if paperwork is filed in time, sometimes the judge does not have it um, to his or her fingertips. So always be mindful, always ask, and always walk with a copy of everything that you're relying on, because you can save so much time and be efficient in that way. Engage with your judges on contentious points. Now, that may be a bit intimidating at first, but you have to. Some judges' manner may be a bit intimidating. I know that when I first began, I felt a bit overwhelmed because it's just a different environment. It's very, very formal, and it's easy to be intimidated or feel intimidated by the judge. But remember to be courteous, always to be polite, and firmly continue to advocate for your client. If you don't speak up, the judge would never be able to consider your good points. Please also remember that if you feel overwhelmed, cast those feelings aside by remembering that in this moment, it isn't about you, it's about your client. Speak up for your client, okay? That's what I do. Even if I feel a bit nervous or I feel like, okay, this judge is just being a bit intimidating, or I feel a bit intimidated, you need to remember, right, I'm here to represent so and so, and I am the best person to speak on this person's behalf. I've studied the case, I know the case law, and I've got some submissions to make. You can do it. Also, it's important to know when to yield. Advocate fearlessly, but it doesn't make sense banging on about on a point that a judge has already stated that they will rule against. You need to know, you need to be perceptive, because there's certain points where yes, you can continue to try to persuade, but you need to make sure that you're not doing exercise. It's not futile. That's what I'm trying to say. You don't want it to become a futile and frustrating exercise. So know when to yield. You will only frustrate the judge and make it harder for yourself to convince the judge on other points. So you need to know when to continue to try to persuade, or when to say, you know what, I defer to your guidance, and move on. Know when to move on. Always know and understand your client's position on costs. Costs was that word that myself and a lot of my colleagues on the bar course did not like to see. It always used to be so, it always used to seem to be so complicated and complex, but you have to get it right. The cost is what most, if not most, all clients want to find out about as well. So they're interested in their claim, but they also want to know, did you get the costs? So you can't forget that. And the best way to go about it is to make sure that you understand your instructions. So make sure that if they say something and it's a bit ambiguous, you follow up on it, because you have to have exact figures for the judge. Okay, you need to make sure that you do identify your cost position and identify it well, and be able to justify your cost position. So you can't just state say like a global figure and just hope, right, the judge just buys that wholesale. No, you must know the breakdown. You have to know the breakdown, those figures, and how we arrived at that total, and justify why that total is reasonable. Advocacy, people, even as it comes down to the nitty gritty, such as costs. And you recognize that in small claims hearings as well. That's very important. Small claims hearings can be intense, and fast paced, because you're basically doing a whole trial. And at the end of it, when the judge delivers his or her judgment, they will look to you if you've won, and they'll say, look, what are the costs that you're seeking? So make sure you've prepared those figures, you've calculated those figures in advance, because given that it is so intense, you don't want to be trying to calculate on the day or in the hearing and you make a mistake. So try to calculate those things in advance, and talk your judge through how you made those calculations. Ensure that while you are listening to the judge's responses, you are recording those responses. The judge will respond to your submission, so try to record those as much as you can, because you will need to write it in the attendance note. Try to also write the order verbatim when possible. I know you may feel a bit nervous to say, excuse me, could you repeat? But you have to. If you don't know the order, I can guarantee the client does not know the order either. You are the person, you are the mouthpiece, you are the person that has to relay this information to your professional client and or your lay client. So make sure you know the order. Don't be shy. Speak up. Ask the judge, could you kindly repeat that? I've got up to paragraph 2, but I'm missing paragraph 3. Could you kindly repeat that? Okay, and the judges are usually helpful, so they would repeat. Post hearing, let's talk about it. So we've just finished our hearing. What do we do now? So we walk out, and if we have lay clients with us, for example, if it's an infant approval settlement, we need to speak to the parent, to let the parent know, right, this is the outcome. How does this outcome impact you? So the judge has settled the claim for X amount. This money will be allocated to the court funds office, or it will be allocated to the bank account that you would have provided. And this money will be only accessible to the child at 18 years old. For those of you who don't know what an infant approval settlement hearing is, it's really the conclusion of like a personal injury case for a child, for a minor. A judge has to make sure that the amount sought is reasonable, and they have to make sure that the child has fully recovered. So parents often act as litigation friends. Litigation friends, literally what it sounds like, they're their friend throughout the court process. So we want to be explaining things to them. We also want to be explaining things to our lay clients in our small claims hearings, because most of the time your clients will not understand elements of the judgment or the order. So you need to be able to break that down into layman terms or plain and simple English. Always report the outcome to the professional client. Let them know the judge's order and remind them that all details about the hearing will be in the attendance note. You also have to write your attendance note. Remember, I spoke about during the hearing trying to jot down the points that the judge has made in response to your submissions and also your submissions. So now is the time in the attendance note to record your submissions and the judge's responses. And this also is very beneficial to the client because they need an account of what transpired. It can also be very helpful, especially if they have subsequent hearings. They can understand why the judge disagreed with the position and figure out ways to counter it. This note must be written professionally. It's a reflection of your advocacy. That's what I think. That's my opinion. Other advocates will have different opinions, but this is a professional project, as I put it. You want to be rating well, clearly, so that they know that you've tried your best in the hearing. You want them to have an accurate record of what has happened. You also want to be able to summarize quite well. So as much as you want to let them know what has transpired, you know, you don't want to be writing things like the judge paused at this time and took a sip of water. That's that's not necessary. So use a discretion, summarize where you can while getting those relevant points in. You can also keep a record of your attendance notes in a secure place. Make sure it's very secure. I also like this one. I reflect on the hearing. Reflection is key. You never ever stop learning. So I've been doing this now for a good few months. And I have a lot to learn. I keep learning all the time. So I always ask myself, what did you do well? Did you receive any compliments from the judge? Because sometimes you are complimented. I've been complimented by different judges. So you use that as a continuous benchmark. What did you learn? How can you improve? Do you need help improving? That's a big one. Contact your advocacy manager if you don't understand something. You can only get better by asking questions and learning from those with more experience. That's important. We have to accept what we do not know. And in this role, we get briefs for areas of law that we have no experience in or we haven't done before. So you need to be comfortable enough to call your manager or whoever you liaise with at the company to discuss these papers, because you always want to be representing the client. So do that. Always self-reflect. Reflection is something that never ends. I know I spoke about data protection earlier, but I think it's definitely worth mentioning again. You must destroy client papers virtually and physically as they contain sensitive information. Invest in a shredder. So I have a shredder. That's what I do. It's done, it's over, it's dusted. Forget about it. Put it in the shredder, watch it go down to confetti bits. That's the way I say goodbye. Anyway, so you invest in a shredder, you shred. Put the virtual papers in the virtual bin and then empty that virtual bin. Because some of us forget that, it's all well and good to put it in the bin, but you have to remember to empty that bin. Especially for you Mac users, you know that we put things in the bin and forget to empty it. Empty it. Remember that we should not be retaining personal information for longer than we need. That's it, people. That's all I've got. But I do have some interesting clips of me on the way to court. So you see me in the train. I'm going to add some of those videos after this. I hope you enjoy it. And you will see me at court just before conferencing, just to let you know what I'm doing. You will see some picturesque scenery as well. I hope you enjoyed the images at the end. If you do have any queries, please do not hesitate to reach out to me. I am on LinkedIn. I'm on Twitter, I'm on Facebook. Please do not hesitate to reach out to me and ask me any questions, okay? I hope you did find this video useful. I hope you found it helpful. That's a wrap, folks. That's all I've got for you today. Enjoy those clips. I'll see you guys later. I'll see you on the next video. Have a good one. See you. Okay, so it's a pretty empty train. So this is the best time I find I can do some work on the train. I'm actually going to Hull today. So I'm here at court. I always arrive nice and early so that I can settle myself and settle my paperwork, and also in time to conference with the defendant in the hearing. So I'm here getting ready to just get myself